Next case on the docket is KATHRYN BORLAND versus SUNJET Aviation, Inc. et al. Let me remind counsel that our oral arguments are streamed on the internet and are also archived, so to the extent we understand there is confidential or sealed information, you may want to avoid specifically referring to those numbers or that confidential information, or it will be part of the streaming and the archives.
May it please the Court, my name is Brett Powell, representing the Borland estate. The question presented on this appeal is whether a trial court has unlimited discretion to divide settlement proceeds as it sees fit, without the need for any evidentiary hearing, without the need for any reports from guardian ad litem representing the minor's interest in the estate.
Let me ask you a couple questions, because I think at least I'm pretty well familiar with the facts of the case. Was any court approval required for the parties to enter into the global settlement?
Yes, Your Honor, we believe there was, indeed.
So the global settlement could have been set aside in its entirety?
We believe that, yes.
All right, and so was that global settlement presented to the court for approval?
Your Honor, in the apportionment and approval was all done kind of in a single, one fell swoop, if you will, Your Honor. This is what the Borland...
Was the hearing before Judge Cohen limited to how should we divide up this number, or was the judge presented with a threshold question of will you approve this overall number?
Well, in fact, Your Honor, subsequent to the allocation decision, the trial court then conducted a settlement approval that allowed distribution of the settlement proceeds. We objected...
Subsequent to the allocation.
Subsequent to the allegation.
So at the time that you all were arguing about allocation, nobody presented to the judge that he had to also determine whether the overall global settlement was acceptable. Is that correct?
That needed to be done according to the arguments below at the time of distribution. The settlement needed to be done before the trial court could have any funds released out of the accounts.
Because he had to review it for purposes of protecting the interests of the minors. Is that correct?
Yes, Your Honor.
If there were no minors involved in this case, would the court have any authority to divvy up settlement proceeds of a global settlement?
Your Honor, I believe the court has some discretion here, but I don't believe that discretion is unlimited. And in this case, that's what the trial court, if this court were to affirm the trial court's actions, it would be an unlimited discretion.
And as I understand it, you all entered into a global settlement with hopes that you all would work out some way to allocate the money, and then you weren't able to allocate the money.
That's correct, Your Honor.
And you entered into a settlement that didn't set forth any backup plan in the sense of if you couldn't agree on how to allocate. These are the factors that ought to be used. Here's who ought to decide how to divide it up. Here's what can or can't be taken into consideration. None of that was put into the settlement.
Your Honor, the settlement contract specifically states that if that agreement can't be reached, then the parties would take it to the trial court, to the probate court, and the probate court would conduct its hearings with regard to guardian ad litem, specifically including guardian ad litem reports.
And is that what was done?
Absolutely not, Your Honor. That is not what was done.
If the agreement called for it gave the authority to the probate court to allocate the proceeds, what authority did the circuit court have?
The trial court has argued to the trial court, and the trial court determined that it had in its capacity, sitting in joint capacity as in its probate capacity as a circuit court judge.
Did the global agreement between the parties attempt to set forth what factors the circuit court should apply?
Specifically included a guardian ad litem reports, Your Honor.
I'm sorry?
It specifically included guardian ad litem reports, Your Honor.
The agreement included guardian ad litem reports?
It included that the probate court would review recommendations from the guardians ad litem.
Can you show me where is that?
If I may, Your Honor?
Yeah.
in exhibit, I believe it is exhibit D of the settlement agreement. It is understood and agreed by releasers that the probate courts having jurisdiction over the administration of the estates of decedents must approve the appointment of guardians ad litem for the minor children of decedents and plans for distribution of proceeds for the benefit of such minor children as recommended by the guardians ad litem before any settlement proceeds may be distributed. That's paragraph 11 of the release of all claims. It's included in Exhibit B to our supplement of the record, Your Honor.
It sounds to me like that's talking about a different stage of proceeding. At this point, we're talking about under the Wrongful Death Act, how's the settlement apportioned between the estates, with the personal representatives under the Wrongful Death Act as the only party to that proceeding. Once you get past that, as I understand it, then you decide with respect to your clients, for example, how those settlement proceeds are distributed between the different claimants to the estate. And it's at that point that it sounds like that document's talking about, and under the law that would be correct, the court has to consider the recommendations of a guardian ad litem. Why is that inconsistent with what the judge did here at the earlier stage when we're only talking about distribution between estates with the personal representative as a sole party and not minor children as a party?
Well, Your Honor, first of all, the two statutes, Section 744-301 and 744-391, both require, in the alternatives, number one, if the gross settlement involving a minor equals or exceeds $25,000.
We're talking about what happens in probate, correct? That's what the statutes are governing. Okay.
Well, this circuit court was sitting in its probate capacity here as it makes the determination regarding allocation to the individual estates, including these minor.
Allocations to the individual estates or allocations to the minors?
Allocations to the individual estates, which of course include the minors.
Let me ask you this question. You said something. Are you saying that the judge was sitting as a probate judge and as the judge trying the...
As the circuit court, he determined that he had current jurisdiction.
Well, let me ask you this then. Was there another judge assigned in the probate case of these parties?
Yes, there was, Your Honor.
Was that the same judge who was assigned to do the personal injury case?
No, Your Honor, it was not.
Does the record show that the probate judge sitting in a separate division ultimately approved the settlement that was the discussion here today?
No, Your Honor. In fact, he specifically refused to rule on that issue because of Judge Cohen's previous rulings. He stated that Judge Cohen had already made the ruling. This was currently going to be appealed because we argued that Judge Cohen's procedure was in error, and therefore he was not going to touch the allocation or distribution decisions. He was going to sit back and let this court resolve the issues.
Well, let me ask you, so if we just affirm, then at that point the probate judge would consider the guardian ad litem's recommendations and make the allocation in each estate between the claimants, correct?
No, Your Honor, because at this point, because the probate court judge made that determination, the appellees in this case went back to Judge Cohen and asked for a distribution of the proceeds, which Judge Cohen granted. The proceeds have already been distributed among the three appellee estates.
But they haven't been approved by the probate court.
Exactly.
The probate court has done nothing.
That's the position we're in. We could not get the proper hearing before Judge Cohen. The probate court wouldn't rule because of what Judge Cohen had done, and the distribution takes place without.
But did you misspeak when you said Judge Cohen was sitting in his probate capacity, because actually he was not?
Yes, Your Honor, I did. What I meant to say is that Judge Cohen determined he had concurrent jurisdiction with the probate court to make the determinations that he did.
Okay.
And so therefore he preempted the probate court's decision. Now, Your Honor, I understand your point about whether or not this goes to the distribution to the individual minors or to the estates themselves. But the point here is that for any meaningful representation of the guardian ad litem, the guardian ad litem must be able to present evidence prior to the distribution to the individual estates. Otherwise, hypothetically, let's say that this global settlement up here was $10 million.
Yes. How were you denied any? I mean, as I understand the record, Judge Cohen said, I have a difficult discretionary decision to make. I want to consider everything you want me to consider, so submit it. And you could have submitted reports from guardian ad litems if you'd chosen to do so. I don't understand how you were denied an opportunity to do that.
Well, looking at the record, Your Honor, on February 22nd, 2005, we requested the settlement of apportion proceeds and requested a 1-hour evidentiary hearing. The judge refused, said, I'm going to defer until the result of the trial. Second step, after the trial resulted in a defense verdict for Learjet, Judge Cohen advised counsel for the other three plaintiffs, the appellees in this case, Mr. McNeil, to advise Borland's counsel that he wanted that he was not going to hold an evidentiary hearing, and he wanted all pleadings submitted by I believe it was the 29th of July, 2005. That information was communicated by way of facsimile letter.
All pleadings or all proof?
All pleadings, all proof, anything you want me to consider by July 29th, 2005. Midday July 26th, 2005, that information was communicated through counsel for the appellees to Mr. Ebersol, which is Borland's counsel. So in other words, the court never issued an order, didn't give a reasonable deadline, just simply said, give it all to me within what in effect became 2 days.
Okay, and you submitted an economist report, correct?
No, what Mr. Ebersol submitted was, again, here's an outline of what we can present to you at an appropriate evidentiary hearing.
I thought your brief said that you submitted an economist report. It wasn't part of the record, but I thought that there was an economist report as to economic damages that was submitted.
No, Your Honor, that would have been submitted and along with the guardian ad litem report had the evidentiary hearing taken place.
Did counsel below at any point say we need additional time to get together our submissions and ask for additional time for submissions?
Your Honor, if you look at the response, which is Exhibit F to the court's requirement, Exhibit F, the response to the court's requirement, Attorney Ebersol makes clear, Your Honor, that this is an issue that needs substantial evidentiary production. The court needs to hear the evidentiary issues. It needs to hear the testimony of the guardians ad litem who had been appointed already at that point. And
okay, so I take it the answer is no.
Well, the answer is, Your Honor,
you didn't. I mean, the judge said I want to hear everything. I want to consider everything you want me to consider. So give it to me in writing. Your position was I want a 1 hour evidentiary hearing. The judge said give it to me in writing. And the question is, did you ever say, or Mr. Ebersol ever say, well, I'll be glad to give it to you in writing, but I need some additional time, and request additional time to do so?
He said, Judge, we can't do it, is what he did. He said, I can't make this deadline. We need to have a hearing here. Now, you answered your question. Did he specifically say, Judge, I want an extension on this? No, he did not. Likely should have. But the fact remains that he requested the evidentiary hearing, which we believe the judge had to make his determination based upon the evidence. Mr. Ebersol's letter specifically said that there is evidence we want you to consider. We want to present it to you. Please hold this hearing. The court never directly even ruled on that motion. Instead, what the court did is by letter advised counsels of his decision. And in that determination, he decided that he was going to consider the fact that Stewart and Fraley lost at trial and Borland and Arden settled in order to equate the total settlements between the parties. It's our position that both for the procedural infirmities that we've touched on already and the fact that this settlement is entirely inequitable, it's not appropriate and should be reversed. I'd like to point out, and getting back to Judge Lawson's point here, there is a potential conflict in this global settlement immediately. Any dollar that's given to any survivor here is by definition a dollar that can't be given to any other survivor. The Florida Supreme Court has stated that when you have a potential conflict between parent and child, that a guardian ad litem report must be.
If this settlement had not been a global settlement, but had just been with your client, the estate, walk me through the mechanics of who would have had to approve the total amount of the settlement, who would have had to approve the allocation between the parent and the children, where would that have been done, et cetera?
Well, if it had been a single settlement, as for instance between Learjet and Borland, there is no allocation involved between the estates, obviously. It's simply the settlement between the two. The trial court has to approve it. It then has to go to the guardian ad litem who has to approve distribution of the funds.
The trial court would have to approve the total amount of the settlement because there are minors involved?
Yes.
Okay. Not the probate court?
Yes.
Well, that's not completely correct. If the settlement, you get you get a finite number of dollars for the estate, which is to be distributed within the estate. doesn't the probate court have an obligation to look at the ages of the children,
Yes.
the educational needs, for example, a child may have a disability or may need special help, et cetera, before distributing that within the estate?
Absolutely, absolutely, Your Honor. That's what has to be done after the approval of the total settlement. Yes.
Okay, so two judges are involved, as I understand your position. The civil judge in the lawsuit approves the total amount of the settlement, and then the probate judge has to approve the distribution of the settlement. Is that correct?
Yes, Your Honor. Or the civil court upon appropriate evidence, because they do have dual jurisdiction over the matter. At least we don't challenge that assertion by the trial court. The point here is, Your Honor, this is a legally distinct settlement from this settlement. This involves 4 plaintiffs and 3 defendants. This is only 2 plaintiffs and 1 defendant, brought on legally distinct bases. Stewart and Fraley opted not to settle their claims and voluntarily decided to proceed to trial.
You could have put that provision into your global settlement if you'd wanted to, right?
What provision, Your Honor? I'm sorry.
You could have in the global settlement said, if we can't decide how to allocate it, we're going to go to the judge to allocate it, but we're going to agree that monies received from other settlements can't be factored into it. That could have been part of the negotiation on the global settlement, right? But it wasn't.
That could have been included. I presume, Your Honor, it could have included any terms that you wish. But frankly, that isn't, with all respect, not relevant to this consideration. We're talking about 2 separate issues, contract with A and contract with B. Contract A does not have any relevance to contract B. They're 2 legally distinct.
If you'd gone to lawsuit instead of global settlement with these defendants, would it have been admissible or relevant in that lawsuit to present evidence of other monies received from the other settlement? Would it have been a set-off? Would it have been a collateral source? Could it have affected what judgment would be entered by the court in that lawsuit?
Given what procedural issues may have occurred during that hypothetical trial, Your Honor, possibly there could have been issues involved raising.
If it could be potentially relevant in a trial context, why is it not relevant to allocation in a settlement context?
Because, Your Honor, first of all, had there been an evidentiary hearing, the trial court could have balanced the equity, conceivably, of...
Well, that's a different issue. One issue, I heard your issue to be, this is irrelevant, it shouldn't be considered at all, it's a separate lawsuit. That's got nothing to do with whether or not you have an evidentiary hearing.
That's true, Your Honor. I agree. My position here is that it is irrelevant. It shouldn't be considered. But
it would have been potentially relevant if you'd gone to trial rather than to settlement.
Your Honor, I don't think so. But frankly, that's an issue that we never reached, we never was presented to the trial court below.
Is your argument that the judge, in essence, punished the parties for going to trial?
Absolutely.
Well, is there any rule that requires the judge to, 1, distribute the monies equally among all the people who had claims?
No, Your Honor, there's no requirement.
So the judge has discretion based on the number of children, the length of the marriage, et cetera, once the pool of money is available, to distribute it based on the judge's discretion. The judge can consider many things.
Based upon evidence presented to it, the judge could have discretion to make appropriate allocations based on the needs of the families and numbers of survivors.
So is your argument that the judge, if he had had more information that you would have been able to provide, had there been a hearing, the distribution would have been different?
Yes, Your Honor. Certainly.
Suppose the distribution was exactly the same after a hearing.
Yes, Your Honor.
What then is the abuse of discretion from the trial?
Your Honor, I would have to see the evidence that the judge in this case did not look at. I don't know how to answer that question.
Would your answer be if he heard it and it came out the same, then you would be happy?
I wouldn't be happy, Your Honor. Of course not. But the point is, if the judge had taken a balanced and reasoned view of the evidence, and maybe...
Suppose he took an unbalanced view of the evidence. That is, he didn't believe the economists, or he didn't give it as great a weight as you would. And the judge said, well, here's how I have the ability, based on the law, to use my discretion. Here's what I'm going to do. A judge may have said, we're going to divide it equally. I don't care how much money you got. We're going to just split it in half, because that's all there is. And then we'll let the probate judge decide how to apportion it within each estate. Or the judge could have said 60-40 or 45, etc. So my question is, Is your argument simply that you don't like the judge's distribution and you want an opportunity to have him do it again, or that the judge did not consider all of the information necessary and it would affect his distribution?
Judge, you've asked a very complex question, and I will give you the opportunity to answer it. I know I'm running out of time here. The answer to the question is, number one, trial court abused its discretion in refusing to follow a proper procedure in which evidence could be made upon which the factors that you're raising, Your Honor, could have been appropriately considered. Factors such as the fact that Payne Stewart was a professional golfer, made a large amount of money. On the other hand, he was a 42-year-old professional athlete whose career could have been cut short by any number of injuries. Whereas Mr. Borland was a 40-year-old architect whose career was unlimited, could have gone on for another 20, 30, 40 years. There is a potential, there is the fact that Mrs. Fraley was an individual survivor who had already remarried, whereas the Borlands and Ardens had 5 survivors in their estate. Those are issues that should have been presented to the trial court, and I believe would have resulted in a different answer. But
I know you're out of time, but I'm going to give you a couple minutes for rebuttal anyway and add it on to the other side's time. But let me ask you, if the court had chosen to divide it on a straight pro rata basis across, I think, 14 individuals,
yes, Your Honor,
did he have to hold an evidentiary hearing?
we believe he should have held one regardless.
Didn't you argue below that if you divide it into 14s, you don't have to hold an evidentiary
We
hearing?
argued below, Your Honor, as the court had already determined that it wasn't going to hold that hearing. And so we argued that, Your Honor, we need to have an evidentiary hearing. But if we can't talk you out of the decision you've made to not hold the evidentiary hearing, at least just divide it up evenly, because there are so many factors that have to be considered that you're refusing to consider. At least just divide it up evenly. Judge Thompson, may I finish the answer to your question?
Yes.
Okay. The point to be made there with regard to whether or not the judge has discretion to try to balance out these sums. If Stewart and Fraley had won $100 million in their trial, which is what they were seeking, would the trial court have been within its discretion in requiring them to give $20 million to each of Arden and Borland survivors, or each of those estates? Of course not. It's a legally distinct issue. When you opt to go to trial, rather than settle your claim, you run the potential of either receiving a much larger compensation for your injuries, or as opposed to settling your claim and knowing that you have the bird in the hand of having a compromised amount. The judge couldn't certainly require Stewart and Fraley to contribute to Borland and Arden. At the same time, he couldn't look at Stewart and Fraley and say, you know what, you won large at the trial. Therefore, it's my subjective opinion that you shouldn't get anything out of your claim that you made with Honeywell Northwest and Jet West, even though you negotiated and bargained for that quantity of money or a percentage of it. I'm going to give you $0, or I'm going to give you 1 penny for it. No, because these are 2 separate settlements, 2 separate contracts entered into. Borland and Arden voluntarily agreed to compromise a claim that a jury later on found, as Stewart and Fraley, was without merit. Because the trial court didn't like that response, it came back and it punished Borland and Arden by awarding Stewart and Fraley a disproportionate share of that settlement proceeds to compensate for the fact that Borland and Arden compromised their claims, as is encouraged under Florida law, and Stewart and Fraley did not. I know I'm well over time. Thank you.
We'll give you 2 minutes for rebuttal.
Thank you, Your Honor.
May it please the Court, my name is Janet Courtney. I'm with the law firm of Lown Strosdick et al. In Orlando. I'm here on behalf of the appellees. Again, I was not trial counsel. I'm assisting with the appeal. That is relevant to bring to your attention in part because of matters outside the record, which is what my focus and my awareness is limited to in having participated in the appeal and in making my arguments today. Opposing counsel, however, brought to the Court's attention matters with respect to allocation of the settlement proceeds or attempts to have that allocation determined, matters attempted to be brought before the probate court, all of which occurred subsequent to Judge Cohen's order in this case and is not proper to be considered by this court. Your Honors, this is a very unusual case. I don't generally handle wrongful death or personal injury suits, but my understanding is that in most of those cases, before a release is given to the party from whom you're getting settlement proceeds, and there are a number of co-plaintiffs with whom that settlement is supposed to be distributed, you usually decide at that stage of the case who is going to get what. That didn't occur in this case, and the parties attempted over the course of approximately 8 months to do that before appellant first petitioned the court and filed a motion to ask the court in its equitable jurisdiction to decide that allocation.
Do you agree that the court had to approve both the overall amount of the settlement and the allocation?
Your Honor, there is a provision, there's a statute under the wrongful death chapter that where there is a settlement affecting the interests of a minor, the court must approve the settlement.
Okay, so if this had not been a global settlement, but a single settlement with a single estate in this case, it would have had to go to the court to approve the overall amount of the settlement as well as then approve how much of it goes to the children. Is that correct?
Your Honor, I've not researched that issue precisely, but my recollection from the statute is that where the interests of a minor child are at issue, the court must approve the settlement.
And does the approval of the settlement in that context where we don't have multiple plaintiffs require an evidentiary hearing?
I beg your pardon?
Does the approval of the overall settlement, if there were only one estate in the settlement, require an evidentiary hearing?
No, Your Honor. There's nothing in the statute providing for it. I'd also like to point out to the court that that isn't an issue raised by the appellant in its brief or that was argued before the court below under the wrongful death statute. What I'd like to jump ahead and argue about, Your Honor, or present to the court is that this is procedurally unusual, as I mentioned before. There is no statute or case law saying what does the court do if the parties say, we entered into a settlement, we have this big pool of money, there's 4 estates, 14 survivors, we can't come to an agreement. Please help us. Now, typically, when there is an interest, a property interest, or some other interest protected by the Constitution, procedural due process is invoked. And if you want to argue that you've not been denied procedural due process, the case law provides that the process that you are to be afforded is affected by the interests that are at stake. Typically, at a minimum, notice and an opportunity to be heard must be provided. Depending upon the interest, you may be afforded the opportunity to require sworn testimony, the opportunity to interrogate witnesses on the other side. But if you have a knowledge at all of administrative law or proceedings that are brought before local governments where procedural due process is an issue at all times, those kinds of rigors of procedural due process, such as sworn testimony, the right to cross-examine, have the rules of evidence apply, aren't invoked. In this case, the appellant has not challenged procedural due process. He's not even arguing that he wasn't afforded minimum requirements of procedural due process, consisting of the right to appear, the right and the opportunity to be heard. What he's arguing is that the court gave that opportunity. However, the court should have afforded an evidentiary hearing, not under procedural due process requirements. And that's very important, I think, for the court to focus on. His argument on appeal is limited to 3 statutes, providing not for the requirement that an evidentiary hearing take place, but provide for the requirement that the court consider a guardian ad litem's report. This was not presented to the court in his motion to supplement his amended motion to provide supplemental argument to the court on how it should allocate the proceeds. Additionally, as the panel pointed out, there was no objection that I don't have enough time, there's additional evidence, there's additional reports that need to be prepared in order to make my client's case. All that the appellant argued is, this is so difficult a decision to make. Everyone's pain and suffering is the same. You cannot argue that one human life, on the basis of pain and suffering alone, is any more important than any other human life.
Isn't that directly contrary to what we do with juries all the time in personal injury suits? Don't we, in fact, ask juries to attach numbers to pain and suffering and to consider the pain and suffering of each individual party and assign a number accordingly?
Forgive me. I'm characterizing appellant's argument. I'm not ascribing any level of correctness to it. In essence, what appellant asked the court to do was, this is so complicated, don't bother yourself with focusing on the economic loss. Don't focus upon the fact that between two of the plaintiffs alone, their economic losses over the course of their lifetime were in excess of $100 million. Don't focus on the fact that Payne Stewart's estate alone had an economic loss of $93 million. There are 14 survivors here, just a portion, 1/14 to each of them. And it's only if you disagree with that I would like an evidentiary hearing. But that's not what Judge Cohen ordered. Judge Cohen said, anything you want to submit to me, I will consider.
How does a trial judge properly consider evidence if it's submitted without being subject to an evidentiary hearing where there can be cross-examination and an analysis of it?
Well, Your Honor, again, that's what I started out with in my argument. This is not a case challenging procedural due process per se. That argument has been waived. The only argument before you is whether the trial court erroneously entered its order without considering the report of a guardian ad litem. Those three statutes cited in their brief do not require an evidentiary hearing. It requires the report of an input from the guardian ad litem. And in this case, there is no statute or case law saying what the procedure is. In effect, the parties requested that the court do equity. And the difference between cases at law and cases at equity is that the equity jurisdiction of the court invokes the conscience of the court. And that's what the court considered in this case. As one of the members of the panel pointed out, the amount of the total settlement proceeds at issue in the case would have properly been considered were this case to have gone to trial in terms of issues of set-off. Judge Cohen had a very difficult decision to make in this case that the parties themselves weren't able to come to. There was no specific statute or case law setting forth what he should do. And again, I can't impress upon the panel enough, this is not a challenge to procedural due process per se, only that the court improperly did not consider a guardian ad litem's report.
Well, wasn't one of the arguments that the trial court erred because he didn't hold an evidentiary hearing? Not simply look at the guardian report, but didn't they ask for an evidentiary hearing that was denied?
Well, in the very first motion they filed, which was 8 months after the global settlement was entered into and the distribution could not be agreed to, there was just very general language saying the parties can't agree. Please help us, give us a preliminary indication on the type and amount of evidence that should be required, and we would like an evidentiary hearing. When it was clear from the court that he was not going to conduct an evidentiary hearing, all that they submitted in response to that directive was, here's what we have to submit to you. And I would like to get into, Your Honor, what they did submit on the issue of economic loss. All they said was, we suggest that because there are so many variables in this case, 4 surviving spouses, one of whom has remarried, 10 children, one surviving spouse has 5 children, one has 4, one has 2, one has none, all different ages. These are such complex factors. Ignore all of that. Ignore the disparity in income. just give us 1/14. That's what's fair. But if you decide to do otherwise, then let me submit my evidence. That's not what Judge Cohen ruled. He said, you have until this date. What they did submit, aside from what they set forth in their brief, which was an economist's report, the fact that it wasn't final, the fact that it was submitted at mediation, they could have requested an extension of time. They did not. They also submitted general statements from someone involved in 9/11 allocations that, economic losses in such cases of tragedy shouldn't be considered. Everybody's pain and suffering is the same. But if you look at the deposition of Mrs. Borland that they have in the appendix, and if you read that, you will see that that what was attached as an exhibit were the income tax returns for Mr. Borland from 1994 to 1999. Additionally, there was an answer to interrogatory attached as an exhibit to the deposition reflecting what his earnings were. What this court has to presume in reviewing the record on appeal, where the appellant has the burden to demonstrate error, is that the court had before it evidence of the economic losses in this case, the huge disparity in the earning power and the losses between appellants, forgive me, and Arden and Borland. The appellant in this case did not submit to you the economist's report, submitted to you the deposition, but not the answer to interrogatory or the income tax returns that the deposition exhibit clearly reflects were to be attached. For that reason alone, in combination with their failure to properly preserve the error that they now contend on appeal should be considered by this court, should be enough for you to affirm the judge.
Let me ask you this question with relation to the second point being whether the court should properly have considered the Learjet trial results in allocating the money. At the time that Judge Cohen allocated these proceeds, there was an appeal in the Learjet case pending, correct? Did Judge Cohen make any provision for revisiting it in case the appeal resulted in a different result?
No, Your Honor.
So he did an allocation that was going to stick regardless of what ultimately happened on the appeal or a new trial in the Learjet case, correct?
Yes,
Is that a problem?
it is not for purposes of my client's position, Your Honor, because on appeal there is in appellate procedure, there is what's known loosely as the Tipsy-Coachman rule, and that is that if there is any reason why the trial court can be affirmed, even if the court states an erroneous reason, this court must affirm. That, combined with the appellant's failure to submit a complete record before the court, it did not make, it contends now that the trial court erred in giving it a sufficient opportunity to present evidence of economic loss, because it failed to provide an evidentiary hearing, and it failed to give appellant the opportunity to submit its complete case with respect to economic loss. Yet it didn't take advantage of the window of time when that opportunity was presented. And it
was never given a window of opportunity to have an evidentiary hearing, correct? As I understand it, they initially said, we want an evidentiary hearing. Judge Cohen said, I'm not going to give you an evidentiary hearing, but you can submit evidence outside of a hearing.
Correct.
And their position was still, we're entitled to a hearing. That preserved that issue for appellate review, right?
No, their position was still, we're entitled to a hearing if you don't apportion 1/14 an award to all.
Okay. And if this court were to determine that they were entitled to an evidentiary hearing, it really becomes irrelevant what they did or didn't submit to the court under this alternative proceeding that didn't involve an evidentiary hearing. Would you agree with that?
No, Your Honor, again, because of my threshold argument, which is that procedural due process is not before you as an issue on appeal.
Why not? Why isn't that before us if their position is we asked for an evidentiary hearing and the judge told us we couldn't have an evidentiary hearing, and as a matter of law, we're entitled to an evidentiary hearing? If that's their argument, you can disagree with the merits of it, but if their argument is we asked for an evidentiary hearing, we're entitled to an evidentiary hearing, and the judge wouldn't give us an evidentiary hearing, why don't we then have before us the issue of whether or not they were denied procedural due process because, well, or that they were simply, it was an error of law to not give them the evidentiary hearing?
Because their sole argument on appeal is that the basis for them being entitled to have an evidentiary proceeding are the 3 guardian ad litem statutes that they cite. They do not make an argument about general procedural due process.
And so the controlling issue becomes whether under those statutes they are entitled to an evidentiary hearing.
Yes, Your Honor. And as demonstrated in our brief and as evidenced by the discussion and your questions of opposing counsel, those statutes are not implicated at this stage of the proceeding. They are not implicated until the award, which was awarded not to the spouses as survivors, but to the spouses as personal representatives. It is once those personal representatives are going to make allocations to the estates and the various claims, including the claim of the spouse, of the surviving spouse, and the children, that those statutes are implicated. And the fallacy of appellant's argument is evidenced because if their argument is correct, if their statements of the law is correct, it did not get implicated at this stage of the proceedings. It was implicated when the global settlement was entered into.
Let me ask you this question. It was argued that Judge Cohen was also sitting as a probate judge. That is, not only did he approve the global settlement, in essence, he approved the distribution when he allocated it to the various estates. My understanding is that the court has divisions, and the probate court still must approve the distribution to the estates and to the children within those estates. Is that accurate?
That's correct, Your Honor.
That the children also will be represented by an attorney, a guardian ad litem, to protect their interests from the parents, not that the parents are mean-spirited, but simply they may be in conflict with the distribution. Is that accurate?
That's correct, Your Honor.
It was argued also that the awards as determined by Judge Cohen is binding on the probate court. Was that briefed? Because I don't recall seeing it, and I don't recall seeing it anywhere.
No, Your Honor, that was not briefed, and I frankly don't understand the argument because there's nothing in his order stating that it is binding, and there is nothing. Judge Cohen's order did not make an allocation amongst the competing interests of the surviving children.
But only as to the estates.
I beg your
But
pardon?
only as to the estates.
Right, just made a lump sum award to the estate and then said to the personal representative, you now divide it up. You have creditors' claims, you have the surviving spouse, you have the children. At that point in time, the conflict of interest or potential for it comes into play. And it's at that point in time that the guardian ad litem needs to be appointed to protect the interests of the children.
Was Judge Cohen presented with the issue of whether or not the overall amount of the lump sum settlement was reasonable?
Your Honor, that's not in the record. Again, I was not trial counsel, and I am not familiar with that for purposes of advising you yes or no.
Does the record show that all of the parties agreed to the global settlement? That is the lump sum?
That is stipulated in the briefs.
So the only question then was how Judge Cohen was to distribute it. Is that fair?
The only question is how was Judge Cohen to distribute it based upon the parties' request because they could not do
Correct.
it themselves.
Correct.
Correct.
And what was supposed to be the controlling precedent or standard for the trial judge in doing it? What factors and what's the source of the factors that the trial court was supposed to use in deciding how to allocate a global settlement?
Well, that's, again, part of the argument I made in the beginning, which is that this is a very unusual case. In most cases, when there are co-parties, co-plaintiffs, and a lump sum to be allocated amongst them, they don't settle until that's decided. And additionally, there is no case law. There is no statute
So is
stating.
it your position that Judge Cohen had unlimited discretion? There could not be an abuse of discretion? If he'd given one of the parties $1, that there's nothing that could be done about it because there's no standard set forth in the agreement or otherwise, and he has unlimited discretion?
My position, Your Honor, is that the appellants have failed to make the case before this court. They have not challenged procedural due process. They have limited their argument to the fact that the guardian ad litem reports weren't required by the court when clearly those statutes aren't implicated. And they also argue in their second point on appeal that the trial court wrongfully considered the outcome of the trial that these Brightly and Stewart participated in. Unless there are any other questions, I have no further argument.
Thank you.
In their response, the appellee argues that we have waived the issue of due process based upon the idea that we did not properly argue for an evidentiary hearing. It's important to remember, first of all, that Borland did specifically request an evidentiary hearing.
I think the argument was that you didn't raise that issue on your brief, and I don't see in your brief anywhere where you raised procedural due process.
We have argued that the interest of the minors have to be protected
Under those three statutes.
through the course of an evidentiary hearing. We specifically cited to this court Mistretta versus Mistretta, in which this court in 1990 stated, quote, denial of due process occurs when the interests of the child are adverse to the interests of the parent. That is our position, that the trial court did not conduct any proper procedure to ensure the rights and the interests of these children. That is the procedure that...
Well, in deciding how to allocate the global settlement among the various estates, that allocation doesn't involve a conflict between the parents and the children, does it? Because they have the same interest, i.e., we want as much of it to come into our estate as possible to then be divided. Doesn't the conflict only arise when you then have to allocate it between the parent and the children?
Your Honor, if that's the case, then why would the Arden estate agree to pay one-third the amount that the Fraley estate took, despite the fact that it has 5 survivors and Fraley only has 1? The answer is all 3 of these appellees are represented by the same counsel for whatever reasons.
You're talking about a different conflict of interest, aren't you? You're talking about potential conflict of interest with one attorney representing 3 different estates. And there is that potential. I assume they could waive that, and I assume that they did. But that's not an issue I think you have standing to raise. Judge Palmer's question was, isn't it correct that with respect to your client and the interest represented in that estate, they were perfectly aligned when you're talking about going after a single pot of dollars, and that is we want to maximize both the children and the parent have an interest in maximizing the total amount that goes to the estate.
In theory, that would be true, assuming that all the guardians and all the minors respond the way that you characterized, Your Honor. We don't know that to be true. That's why the Florida Supreme Court, and that's what the statute requires, that when there's a potential conflict, that the guardian has to be appointed. Indeed, guardians were appointed, they just weren't listened to.
Thank you, Counsel. Your time has expired. We'll take our morning break now. Counsel is invited to join us in the Attorney's Lounge.